Judgment in the matter of AXA Insurance and another against the Commissioners of Inland Revenue and another.
Lady Rose will explain this judgment.
For many years, the taxing authority in the UK, which used to be called the Inland Revenue, is now called His Majesty's Revenue and Customs, they collected taxes from companies charged on the dividends that those companies either received from subsidiary companies in which they held shares or paid to their own shareholders. Some years ago, it was decided by the European Court of Justice in Luxembourg that the UK's tax regime for such dividends was unlawful under EU law. This was because it gave more favourable treatment to dividends paid on shares held in UK-based companies and less favourable treatment to dividends paid on shares held in companies based elsewhere in the EU. That was a breach of EU law because it hindered the free movement of capital around the different EU member states by discouraging UK companies from investing in companies based elsewhere in the EU. It was always clear that the companies which had paid corporation tax, which had now been found to be unlawful, were entitled to a refund of their money. But there were 3 points that were not so straightforward. The first was whether the companies were entitled to compensation for the loss of the use of their money between the date that they paid the taxes they thought were due and the date when they were refunded the money by HMRC. The second was how to value any such compensation, in particular whether it was enough that they got what is known as simple interest, whereby you get the same percentage of the principal sum for each year you're kept out of the money, or should they get compound interest? The difference in amount between simple interest and compound interest can be enormous when you are dealing, as we are here, with very large sums of tax and the interest accumulates over many years. The third difficult issue was to identify precisely what kind of legal cause of action the companies were entitled to bring to get their compensation. This mattered because if they could show that their cause of action was a claim for the return of money they had paid because of a mistake about the law, then they could claim going back many more years than the 6 years, which is usually the limit on claims to recover a debt. That would be because the 6-year limit would only start running from the date that they could have discovered their mistake and that they did not have to pay the tax, rather than the much earlier date on which they'd actually paid the tax. There were many different taxpayers who wanted to bring the same claim for a refund, and a number of different sets of taxing statutory provisions were all found to be unlawful in similar ways. So there were a series of group litigation orders made. A group litigation order is made in circumstances such as these, where lots of different people are all claiming for the same legal wrong, and they have their claims entered on a register set up by the court. Then a test case is chosen, and that test case is the one which is argued through the courts and which decides all the legal or factual issues that are common to all the claims placed on the register. Generally speaking, once that test case has been decided, then the result of that is applied to all the other claims on that group register. This is regarded as an efficient and cost-effective way of dealing with this kind of situation, rather than having dozens or even hundreds of different claims, all raising the same point, all going through the courts. That would be very expensive and time-consuming and would give rise to the risk that different judges would come to different answers to what are essentially the same questions. In the present case, the appellants, AXA Insurance, were claimants whose proceedings were on a group litigation register. But they were not chosen to be the test case, so their claim had to wait until the test case was decided. That test case was the case brought by Prudential assurance companies. The judge hearing that claim held that Prudential did have a claim for compound interest for the period between the date it paid the unlawful tax and the date the tax was refunded, And moreover, the legal nature of that claim was a favourable one for Prudential because it was a claim that could be pursued in respect of taxes going back many decades. Some different interests in issues in that Prudential judgment were appealed up to the Supreme Court, but not those particular issues. However, a few years later, the same legal point arose in some different group litigation orders, and later on, the Supreme Court decided in those different cases that, in fact, there is no claim for the loss of the use of the money other than a statutory claim that had been enacted to deal with this specific problem. And that meant there was no right to compound interest and no right to claim going back so many years in the past. So there was a mismatch between what was decided in the Prudential test case and what has been decided by this court later in other cases. And that mismatch raises the question whether the AXA appellants in the present appeal should be able to rely on the more favourable test case in their group litigation and be awarded much more generous interest going back many years, or whether, because we now know that the judge in the Prudential test case was mistaken in how he analysed the law, they should be limited to the claim which is in fact for much less. The court's procedural rules, which set up a group litigation order, do confer a power on the court to order otherwise. That is to say, the court does have a discretion to order that the result of the Prudential test case should not apply to AXA and the other companies on the Prudential cases group register. But the legal rule, the procedural rule, doesn't say anything about when it is or is not appropriate for a court to deprive the companies on the group register of the benefit of a favourable judgment in their test case. And it's clear that if courts order otherwise in lots of cases, that risks undermining the whole valuable group litigation order regime. In the judgment being handed down today, the Supreme Court decides that it is appropriate to order otherwise in this case. That means that AXA only receives the compensation that follows on from what the Supreme Court decided in the later different cases, and they don't get the compensation that would follow from what the High Court decided in the Prudential test case. The court in the judgment stresses that it will only be very rarely that it's appropriate to deprive the other companies on the register of the benefit of a favourable decision in the test case. The whole basis of group litigation order regime is founded on the principle that the test case binds all the other cases. Otherwise, there's not much point in having the regime. But the circumstances that arose here are really very extraordinary because there were so many changes in the relevant legal principles over such a short space of time. It would not be right to order the payment of compensation on the basis of a legal analysis which we now know was wrong. The court in the judgment sets out the factors that are relevant when deciding this kind of case. They include that the law is now very clear, so there doesn't have to be further argument and expense incurred by the AXA parties as a result of deciding that the Prudential test case does not bind their case. The appeal is therefore dismissed.